Just to okay, recording. So I will highlight some of the SharePoint circulations that we have. Okay, in the month of June. Okay, one of it is this Court of Appeal case of T Seng Hock against Sambagavali. Okay, anak perempuan Murugusan. Okay, this is a transaction for sale and purchase of a piece of land. Okay, so the purchaser entered into an SPA with the owner to buy lah, okay, the piece of land lah, of the owner's land. The SPA was signed on 12 April 2016. So the owner later alleged that she has never received any payment from the purchaser after signing of the SPA and after the land was transferred, okay, to the purchaser. What happened in this, the transaction, I mean, is a little different from the normal SPA. After signing 10% they got give, okay, it's not disputed. But after the 10% gift, before the balance purchase price was paid, the owner let the purchaser, let me see, okay. Okay, let us just continue. They allege that she has never received any payment from the purchaser after signing sale and purchase, okay. And next slide. So the owner filed action in High Court claiming for specific performance of the SPA. So he wanted the purchaser to perform his obligation under the SPA to pay the full purchase price. So the purchase price was 2.7 million. Okay. Otherwise, if the purchaser cannot pay, they will the land have to be returned back to the owner lah. In this case, what happened is that the land was already transferred to the purchaser. It's a special agreement between them. You have to read the facts, okay, of the case. So the purchaser claimed for BP, okay, together with interest on the purchase price, okay, from 2016, 19 April to the VP date, okay, and alternatively for the owner to return the sum of 2.7 million to redeem the land. So the purchaser's case is that prior to signing of the purchaser defend to the action, he said that prior to signing of the sale and purchase, this owner got borrowed money from the purchaser. Okay, so the 2.2 million. So the owner, next slide. Okay, the owner agreed to transfer the land because he cannot pay back the 2.7. He don't have that much cash, so he offered the land for sale, okay, the property for sale. So the property was valued at 2.7. Okay, so his loan is 2.2, so he have to pay the shortfall of 500K to the owner, right? So the owner received, okay, of the 500K, and in fact he acknowledged receipt, okay, on 12 April when they signed the SPA of the full purchase price. Full purchase price is the 2.7 million, and the owner failed to pay the loan to chargee, okay, because this land is charged to the bank, okay, Maybank. So the purchaser redeemed the land and registered the transfer in 2018. All right. So in 2019, in June 23rd, so the court allowed the owner's claim. Okay, all this happened okay, in the midst when the owner filed the claim also. Okay, so the findings of the High Court, the High Court said that what the High Court find is that the owner did sign the transfer, so there's no question of his fraud. Okay, he never consent or okay, I was cheated of the land by the purchaser, so there's no issue to the transfer. So it's also findings of the High Court that there was a loan. Okay, the owner did get a loan of 2.7 million, actually 2.2, sorry, was given by the purchaser to owner. Okay, and the third fact is that the sale and purchase and the transfer, what the court found is that these were entered to defeat, okay, the National Land Code provision. So the court found that the transaction was illegal. The sale was illegal. Therefore, the title obtained by the purchaser is defeasible, can be defeated. Next slide. Next slide. Okay, so the purchaser, what the High Court found is that the purchaser, yes, he registered the land, but because for to repay the loan failed to clear, so he actually has no intention to purchase the land. So in other words, is that he said the S&P entered was not for really want to buy, because he has no intention to purchase the land. So that is what the court has found, the High Court. So appeal lah, okay, so the parties appeal. And then purchaser's case is that no, he doesn't agree with the High Court decision. So they say his point is that the sale and purchase transaction was genuine. So the question whether the sale and purchase is a sham or not, or there's fraud or not, or whether the land was used as security is not an agreed issue. So there was a friendly loan agreement signed before they enter into the SPA, but there was no connection. So the land was never meant to be used as security for the loan in the first place. Okay, so there was no connection between the two. The owner had never agreed, okay, or there's never any term in the sale and purchase to state that the amount in the SPA will offset the loan agreement. What happened is that this was after, okay, the offset was after, okay, that he couldn't, after the SPA was entered, that he couldn't, after the loan was entered, he borrowed the money, then he couldn't repay. Okay, he has no money to repay back the loan. Then only they agreed to offset, to use the property to offset. Okay, next slide. So the Court of Appeals decision is that, first point, whether the decision of a court can be grounded on matters on issues not pleaded. So the law is settled, it must follow what was pleaded. Okay, so what was pleaded here is that the sale and purchase was genuine. So the issue of whether there's a fraud, is a sham, it shouldn't come in. I mean, the court shouldn't go and consider that and make a finding of that. Okay, so in addition to that is that the owner received loan in 2015, okay, before the SPA was signed, right? So the SPA was only executed a few months after the loan. So if the land is meant to be security for the loan, by right, okay, the SPA should be signed first, right, before the loan was dispersed to the owner. Okay, so this supports the fact that the land was never meant to be security for the loan in the first place. Next slide. So High Court is correct to find that the owner has received 2.7 million, including the 500K, okay, for the full purchase price. So it is also not disputed that the owner had also signed an acknowledgement, okay, in 2016. That was witnessed also by D1, there's a witness there, that the 500K was deposited to lawyer's firm account, okay, and was cleared and released to the owner after deduction. So it was not disputed that he already accepted, okay, got the amount already. So the conclusion is that the trial judge has arrived at the conclusion that was plainly wrong in principle. Okay, so what the parties have already, they have stated what is the agreed issue. The court, okay, the trial judge cannot divert from there. Okay, so if it's a agreed issue, he must follow that. Well, he cannot go and consider or go and explore what was not a agreed issue. Okay, next slide. Okay, this is another highlight. Okay, it's a federal court decision, Zhongzhang Trading against Kwan Hong Cheong and Elaine Gage Chao Song. okay, in April 2021, Zhong Zhang filed a writ in High Court against the respondent. Respondents are the directors of Zhong Zhang, okay, first respondent and second respondent, to enforce a shareholder resolution passed at its EGM in July 2014. So Zhong Zhang was seeking relief that these two respondents to deliver and hand over Zhong Zhang's books and statements, okay, because according to the shareholder, which will go later, the resolution was held that this respondent first and two was removed as director of Zhong Zhang. Okay. Next slide. So there was 3 leave questions for Federal Court: whether the list of members as reflected in the company's register is conclusive evidence of ownership, okay, because there was an earlier Federal Court decision in 2013, and whether there's a corporate representation of a holding company of a wholly owned subsidiaries entitled in law to requisition for an EGM, and whether that resolution, if passed, would be valid and binding, okay. That is the leave question, okay. Next slide, I will explain a bit of the facts. What happened in this case was that Zhong Zhang is a wholly owned subsidiary of KCHSB. So Zhong Zhang is the subsidiary and KCH is the parent. So KCH owned 100%. Okay, wholly owned subsidiary means it owned 100% of Zhong Zhang shares. Until in 2003, these two respondents, R1 and R2, as directors of Zhong Zhang, they fraudulently removed some of the, transferred some of the Zhong Zhang shares to themselves. So as a result, this KCH was no longer, resulting in this KCH no longer holding 100%. Okay, because some of the shares, Zhong Zhang shares, he has transferred to themselves, to this R1 and R2, they transferred to themselves. Okay, so when this KCH, the parent company, know about this, aware of the fraud, they file 2 separate suits in Sandakan, okay, to get back all the full ownership of Zhong Zhang. Okay, so he seek a declaration that is a legitimate and beneficial owner of all shares issued, 100% shares issued of Zhong Zhang, and also seeking for an order that the register of members, okay, of Zhong Zhang, when they have the register of members, list of the members, okay, be rectified. If you transfer already, okay, then you have to remove the members, okay, then be rectified under section 162 of the Companies Act. So now he's seeking for restoration of that register, okay, to the original listing before the fraud happened. Okay, this was to be rectified under section 162 of the Companies Act. This one was still the old Companies Act because this one has happened before the amendment. Okay, so the claim by KCH, okay, was allowed in 2010, then went to appeal, was affirmed, and until High Court, Federal Court in 2013, it was affirmed. So next slide. So affirm means that the effect of that 2013 Federal Court order is that full ownership, okay, Zhong Zhang got what it prayed for, 100% should be transferred back to Zhong Zhang. That means the respondent who fraudulently transferred to themselves should restore the shares back, okay, to Zhong Zhang. So, but these two respondents did not comply with the 2013 Federal Court order. Okay, he said the respondent, the obligation is not on them. The respondent is on Zhong Zhang to comply with the order. Okay, because the earlier, the 2013 order did not state whose duty to rectify this. So the fact that the Federal Court order does not state which party, does it mean the Federal Court order is bad? Can it be ignored? Cannot, right? So because it's not been set aside. Okay, you can only ignore once it's been set aside. Okay, so it's still a valid judgment. It's still a valid order. Okay, next slide. So 2 weeks after the Federal Court decision in 2013, this parent company appointed a corporate representative, Kwan Hung Cheng. Okay, so this corporate representative go and requisition EGM of Zhongzhang. That means what it means is that a parent company's representative asked for EGM to be held, EGM of this subsidiary to be held. Okay, and fixed this EGM in November 2013 because KCH owns 100% of this Zhongzhang, so they can apply for EGM of the subsidiary. Okay, so these directors, R1 and R2, applied to the High Court to declare the requisition of the EGM invalid. Okay, and to ask for High Court to nullify the resolution of the EGM. Okay, no issue. There was no issue of validity of appointment of the corporate representative. So he issued a fresh requisition notice. Okay, in the High Court one, the court nullified the resolution for this 2013 EGM, but this corporate representative go and issued for a fresh requisition notice, okay, to conduct the EGM. Next slide. Whereby one of the agenda is to remove R1 and R2 as directors with immediate effect. Okay, but R1 as director, he proceeded to issue the notice of EGM. Okay, so he fixed the EGM on July 2014. This is the second EGM. Okay, according to this director, first director, he said not enough quorum. What happened on that day is not enough quorum, so he left. But this corporate representative take over, go and chair the EGM, and then they proceed to conduct the EGM and remove. Okay, they have a resolution to remove this R1 and R2 as directors of Zhongzhang. Okay, with immediate effect. Next slide. So the issue here is that whether this resolution passed by Zhongzhang at the second EGM was valid, okay, and enforceable against the two directors. So to answer this, it would depend, okay, whether this Kwan as corporate representative has the authority to requisition the second EGM of Zhongzhang on behalf of the parent company. So the respondent argued that the requisition was invalid because the parent company was not a member of Zhongzhang. Okay, Kwan was representative of the parent company. So he has no power to requisition for any EGM of Zhongzhang, okay, under Section 144 of the Companies Act. Next slide. Okay, Section 1441 of the old Companies Act, the required requisition of members holding not less than 1/10 of the paid-up capital as at the date of deposit, the directors of a company to proceed to convene EGM. So here should be no issue lah. Okay, KCH is holding definitely more than 1/10 of the paid-up capital. Okay, because it's holding 100% of the paid-up capital. So it's clear that the KCH has the authority, okay, through the corporate representative to conduct the second EGM of Zhongzhang. Next slide. Okay, so Zhongzhang argued that the corporate representative has lawfully passed the proposed resolution, including the resolution to remove the two respondents as directors of Zhongzhang, okay, and to appoint Kwan as the governing director. This was the agenda during the second EGM, which was valid, which has gone on. Okay, so Zhongzhang argued further that first respondent has no power to call off the second EGM. First respondent, okay, no power to call because the rightful person to call off should be the shareholder, okay, not the director of Zhongzhang. Okay, that is because this second EGM is members meeting, not a directors meeting. Next slide. Okay, so the respondents appealed to the Court of Appeal. Court of Appeal allowed, okay, and set aside the High Court decision, since the earlier Federal Court order did not explicitly state that KCH is the 100% owner of Zhongzhang, and that the scope of power of the corporate representative is to attend and vote on behalf of KCH. So there's no mention that he is empowered to issue any requisition, okay, on behalf of the parent company to call an EGM. So the effect of this Court of Appeals decision is to render the earlier Federal Court decision in 2013 not effective, okay, because by this Court of Appeal decision, this parent company is prevented from gaining full control. Okay, next slide. The fact that this parent company's 100% ownership, okay, has not been re-entered, okay, this is what the respondents argue on the register of members, okay. Oh no, this one is what was argued, okay, by Zhongzhang. This does not make the Federal Court ineffective, okay. The Federal Court does not agree with the Court of Appeal decision because the earlier decision was a favorable decision to Zhongzhang and adverse to the respondent. Okay, what the Federal Court decision, and it affirms the decision of the High Court. Okay, because it went up to appeal up to Federal Court. Okay, so which declared that this KCH is the 100% owner of Zhongzhang. So there should be no issue of that. The declaration is clear. Okay, next slide. So the declaration is clear and is until Federal Court ready in 2013. So the respondents, what they should do is to obey the Federal Court order. Okay, but instead, what they put the ball to the obligation to Zhongzhang to rectify. Actually, it's very simple. What they can do is they transfer to themselves the shares. So what they can do is that you retransfer back to Zhongzhang. So it's as easy as that, but they don't want to do that. Okay, so that's the decision of the Federal Court. So for question number 2, whether the corporate representative is entitled to requisition, that means can a parent's representative go and requisition, okay, of an EGM of a subsidiary? The answer is yes, provided that the parent company owns 100% shares of the subsidiary. Okay, next slide. Okay, the Court of Appeal, in deciding that the corporate representative can only attend meeting but cannot requisition notice, also doesn't sound sensical, okay, because this is referred to earlier case of Trico, okay, but that facts of that case and the incident case is not the same, okay, because in Rico's case there was an issue whether this representative was validly appointed, was properly appointed. Here it is shown that this corporate representative was properly, validly appointed, okay, as corporate representative. So there's no issue to his validity of his appointment. So Federal Court held that when a holding company owns 100% of subsidiary and is a sole corporate member, okay, so the corporate representative will have the necessary authority to ask for an EGM of the subsidiary. Okay, so these are the proviso provided it owns 100%. Next slide. So question number 1, just 3 questions just now. So question number 1, list of members not conclusive, okay, because given the effect of the Federal Court order dated 2013, okay, so the current listing of the members, register of members, you still have to correct it. So you cannot treat that as conclusive, okay, until you rectify it. Question number 2, I've explained just now, provided you own 100%. Okay, parents own 100% of the subsidiary. Then only you can requisition for an EGM of the subsidiary. Okay, so question number 3, yes, affirmative. Any such resolution passed is valid lah, by reason of section 152A and 1476 of the Old Companies Act. Sorry, it should be 1965, yeah. So the appeal was allowed with cause lah. Okay, any question before we go to the next slide? Next slide is another case. Okay, on citizenship. Okay, if not, we move to next slide. Okay, this is citizenship issue case on CTEB against Ketua Pengarah Pendaftaran Negara Malaysia. Decision by Federal Court, okay, 28 May 2021. Okay, what happened in this case is that a child was born to a father. Father is a Malaysian, mother is a Filipino. Okay, when the child was born, father and mother not married, so this child is considered an illegitimate child, right? So all three of them, father, mother, and the child, they domicile in Malaysia. And after this child was born, this father and mother subsequently married. Okay, and they proceed to apply to legitimize the child under Legitimacy Act. So there's this procedure. If you are born in, you are born and is illegitimate, okay, not married, then you can go for process of legitimization of the child under this act, 1961 Act. So this application was allowed. Okay, legitimacy was allowed. Next slide. Okay, so legitimacy allowed, so the father go and apply for on behalf of the child for citizenship under Article 14. Okay, read with Section 1B, Part 2 of the second schedule to Federal Constitution. So it provides that, yes, you can gain citizenship by operation of law if we are born outside Malaysia, provided one of the parents is a Malaysian citizen. That's what provided under Section 1B of the Part 2 second schedule. But the Section 1B, Part 2 must be read together with Section 17, Part 3 of the second schedule. Okay, because second schedule to the Federal Constitution, there are a few parts, Part 1, Part 2, Part 3. Okay, so Part 2 have to be read with Part 3. Okay, that provides if a child is illegitimate, the reference to parent, okay, you see under Section 1B, must refer to mother. It cannot refer to father. Next slide. Okay, so acquisition of citizenship by operation of law requires the fulfillment of requisite conditions at the time of birth. Okay, let me just explain a little here. So even though just now the father is a Malaysian, but because the father and mother was not married at the time of birth, okay, even though he's legitimized later, but at the time of birth, the father and mother was not married. Okay, so you want to apply for citizenship under this Article 14, everything has to see at the time of birth. Okay, so what happens to you after your birth? You are subsequently being adopted or subsequently being legitimized. It doesn't matter. For this decision, it doesn't matter. So subsequent marriage of the parents would not change the status of the child. It would not make an illegitimate to legitimate. Okay, so the Federal Court held that the provision in the Constitution was clear. Okay, because party here try to construe, they try to interpret Article 14 with Part 2 with the Legitimacy Act. Okay, because the provision in the Legitimacy Act says that once you got an order for legitimacy, okay, the effect is that you are legitimate from the date when your parents is married. Okay, from the date of marriage. So there's some point to consider here lah. Okay, when I read this, okay, I was thinking whether Legitimacy Act, okay, then what's the point? Okay, what's the point of having applying under Legitimacy Act? But there was things you have to consider. Okay, Legitimacy Act is for the purpose to make that child legitimate. Okay, it is not for the purpose to apply for citizenship. It does not confer citizenship to an illegitimate child. You cannot use that act to apply for citizenship. Okay, similarly to adoption. I've seen some of the lawyers, they go for adoption. Then after the adoption order, okay, they apply for citizenship. Also cannot, okay, the federal court also won't allow. Okay, because the court says that the provision in the constitution was clear enough. You no need to use other law to, like the Legitimacy Act or Adoption Act to interpret. Okay, next slide. Okay, this is another circular. Okay, just now that the citizenship, any comment, any feedback, anything you want to comment? No? Okay, this is SSM direction. I mean, Suruhanjaya Syarikat Malaysia, okay? Practice direction issued, okay, during the MCO. Extension of time to companies to circulate and lodging of financial statement and holding of AGM. You know, companies registered with SSM, under the Companies Act, they have a deadline to circulate, okay? The financial statement and report, okay, they have a deadline. Then lodge with SSM, also they have a deadline. Okay, if they have passed the deadline, then they have to pay a penalty or I don't know. Okay, what's the consequence? AGM also, they have a deadline to hold an AGM, not as and when they want. Okay, so when this time passed already, so what they can do? Okay, so SSM has considered this, the difficulties during MCO, so he has granted extension of time. But this is not automatic. This is not automatic. In the circular, it says that it will extend 90 days from the date when it was last supposed to circulate and to lodge, okay, from the last deadline. But this only applicable to companies with financial year ending 31st January 2021. Okay, so companies, they want to apply, they can submit between 1st June to 31st July. Okay, so still got time. But apparently, I don't know whether this applies in the extension, okay, during the extension. By right, it should apply, okay. But companies can make inquiries, they can check further with the SSM, okay, for further details, further information. Okay, so this is not automatic, you have to make application to the SSM. Okay, but most of the case, they will grant, okay, because of the MCO. Okay, next slide. Okay, this is another circular issued by BC, Bar Council, witnessing signature, okay, via video conferencing. This issue has been hoo-ha from last year, I think, since the start of the MCO for convincing related matters. Until now, Bar Council is of the view that signing, when you watch, okay, person signing in on a screen, okay, in a Zoom, okay, whatever, you know, these online devices, is not the same as in the presence of. Okay, does it mean in the presence of? So Bar Council says this is not the same. Okay, we are not in the same room. Okay, you are not really in the presence of. Okay, although you really watch that person signing in on the screen. Okay, so it advised that any solicitor who wishes to witness signature during under this type of device, I mean this type of system, go and get legal advice. Okay. Next slide. Okay, this was an article, okay, written by this Lim Wijat, okay, a constitutional lawyer. there's issue here, okay, opinions, okay, two divides, whether we should aid or emergency or to extend, okay, must the king follow the advice of prime minister or not? So there are two schools of thought because it derives from these two articles, okay, article under the federal constitution. One is article 150, which says that the YDPA, the Agong, he himself can decide. Article 14, so it's versus, okay, Article 40 versus Article 150 of the federal constitution. Okay, Article 40 says the YDPA has to act on the advice of PM. So basically, it's the PM who makes that, who decide lah, and then go through Agong. Okay, the writer in this case, he's more prone to agree, okay, on Article 40 because our Agong under the Constitution is a constitutional monarch. Okay, these are the principles. It has not been changed. Okay, even though the Agong has the residuary power. Okay, we say residuary power, but still, okay, in general, YDPA has to act on advice of PM. Okay, so you see how, okay, whether this coming August will depend, it will end or will extend, okay, we don't know, but these are the issues, okay, you can explore more on this, okay. Anything that you want to discuss on this, you can come to me and you can discuss it with me, okay. And this another next slide. Okay, this is another article, a very good article, consumer awareness, okay, will writing mistakes to avoid. Okay, these are the highlighted common pitfalls, okay, when writing a will. Number one is the lack of clarity. Okay, it will put the general sentence, okay, inherit a house, inherit this property, but most of the time does not state, okay, does not provide. What about the contents inside the house? If there's antiques inside the house, who will get? Okay, where will it go? If the house there is occupied by tenants, so the rental will go to where? No, okay. So it must be specific enough to cover all this issue, okay, lack clarity. And then there's no residuary clause, okay. Residuary clause is a clause where it will cover things that is not covered, okay, in your main clauses, okay. So if there is no residuary clause, you didn't have this residuary clause, okay. So in the event of any inconsistency or any thing being left out, you have to go to court to get an order, okay, because assets, okay, that you did not provide in the will, okay, or under this clause, not covered under this clause, you'll be treated as falling under intestacy, as if no will, okay. So this is also a very important clause. You have to provide for this residuary clause, okay. And failure to review the will after a life-changing event, after divorce, okay, after the death of a family member, after you remarry, okay. If you have prepared a will before that, it's time to review back the will, okay. You don't want the, before you divorce, you want to your husband as beneficiary, okay, wife put husband as beneficiary. After the divorce, then definitely you don't want to, okay, there's no reason to give to that husband anymore unless you still want to give, okay. So you have to review back the will, okay, after a life-changing event. Failure to grant power of to sell to the executor, this is also very common, okay. If you don't specifically give power to sell to of the property, executor, so what can the executor do? You have to go to court lah to get an order, Okay, everything then if you lack, it's not in the, you did not make clear in the will, you have to go court to get direction. Okay, so there's some of the pitfalls. Okay, and I think is there any other slide? Okay, no more. All right. Okay, so take note. Yeah, the full articles you can read. Okay, through the link that we have provided. Okay, if there's you can't locate or is any difficulty in locating the contents, please let me know. Okay, and we try to make that as easy as, I mean, as convenient to read. Okay, if there's any comment or feedback on the SharePoint updates, let me know. Okay, so we will take into account, okay, in future considerations. Any question, anything want to comment? If not, then okay, I'll end the session. Thank you for participating. Okay. All right, thank you. Bye-bye.
Thank you.